Angus McIntosh. I don't know what the proper introduction is other than this man is simply a walking encyclopedia about the Constitution, about property rights, and I need to shut up because he can't get done with all the information he has in his allotted amount of time, but we're going to hook him anyway. Dr. Angus McIntosh, it's all you.
Thank you.
Thank you, Trent. I don't know if I have the right button here. Okay. That's a long-winded title. Comes from my days in academia where everything had to have a descriptive title, basically, that's a synopsis. So, historical development of split estate, land use and property rights in the West. How to negotiate from a position of knowledge. A lot of people don't even know that Congress ever granted land use rights, but I tell you, if you go to Title VII of the Federal Land Policy Management Act, there's about 2.5 pages of provisions in FLPMA that says that nothing in this act, nothing in FLPMA, Federal Land Policy Management Act, shall affect any prior existing land use right, property, patent, and so on and so forth, and it goes on and on. And Congress does not pass laws that have superfluous language in them. If it says this does not affect any prior existing land use right, it's because there are prior existing land use rights. Okay? The problem, and this is my resume here, I guess, if you want to, I don't know if this has a pointer, that goes down here. That's me. All right, but I think the most important thing on here is admitted expert witness in the federal courts. I've testified in Colorado, Nevada, Oregon, United States Court of Federal Claims, Arizona Federal District Courts. So I'm an expert. All these things that I've done is part of the reason why I'm an expert. Was found to be an expert. And you don't just declare yourself to be an expert. A judge, a federal judge, examines you and you're cross-examined, and if you're challenged by the United States, then the judge in the end determines, is this guy or is this guy not an expert? Okay, and the last time I testified in federal district court, the United States, of course, objected because they don't want the truth to get into the record, and so they always object to me, but it hasn't availed them any good. And the judge finally, he said, well, I'm going to determine that this witness is an expert in whatever it is he's going to talk about, because he'd already read my work, he knew my reputation, he knows that my work is highly backed up by citations. I always give citations. So when people say, oh, that Angus McIntosh, he's a, low life, sorry, bucket of whatever, it doesn't matter. It doesn't matter what they think about me personally. I don't care. And if somebody says, well, Angus, that's just your opinion, no, I'd usually reserve my opinion. What I give you here is there's going to be citations for everything that I give you, either Supreme Court decisions or the actual language of the acts of Congress with the citations to the statutes at large. I do not trust the United States Code. There's actually things that aren't in the United States Code that were enacted by Congress as an act of Congress that's in the statutes at large, such as Title VII of the Federal Land Policy Management Act. That is not in the United States Code. Yet it is a piece of legislation Congress passed for the specific purpose of protecting prior existing rights. Now, why didn't the Justice Department put it in the United States Code? I don't know, unless maybe perhaps they don't want people to know about it. Okay, so, and I've had numerous attorneys tell me, Angus, man, I've checked your work and you are right on. And I'll throw out the same challenge right now that I throw out every time I give a talk. Said, if you think there's anything wrong in my research, please come and tell me. And 18 years that I've been given, I've probably given 180 to 190 presentations on this topic. Only one time did an attorney come to me and say, you know what, I think you missed something on this. And I looked it up, and he was correct, and I corrected it. But anyway, I'm just going to get into this. This is, what are property rights? How are they created? This is the philosophy that's guided our country from the very beginning. It's from John Locke's second treatise on government. Basically what he says is that in a wilderness state, everyone has the right to go out there. Let's say this was a wilderness, nobody lived here. Anybody could go out there, cut down a bunch of trees, limb them up, skin them, notch them, stack them up, build a house, and now he has created a right of property. And the way that happens by natural law is you have now mixed your labor, your sweat, your time, your energy with this object of nature. Now there is something attached to that log that makes it yours. When it was just standing there as a tree, it was available to anybody and everybody. But because you mixed your labor with that object of nature, you have now created a right of property. And you now have the right to use force, if necessary, to defend your property. Because now there's a part of you. That log is an extension of your labor. You have built that house. For somebody else to come along tomorrow and say, well, gee, look at all these logs. They're stacked up really nice. I'll just move in. You have a right to defend your property. This is the view that's governed our country from the very beginning, and every federal land disposal law that Congress has ever passed has required either actual mixing your labor with the land, such as the homestead laws. You had to live on the land for 5 years, you had to till the ground, you had to build a residence, you had to live there 5 years, and once you had done that, you have now earned that property and you could obtain a patent. So this concept of John Locke permeates all the federal land laws, every single one. This Lockean concept of mixing your labor, time, and effort with natural resources to create property rights predates the Constitution. It runs like a consistent thread through all the public land laws. The idea of settlement, appropriation, possession, occupancy, and use, all these words are in quotation because this is the language that's found in all of these statutes. They're consistent with the language used in all of these laws, from the preemption law down to the desert land laws, the mineral land laws, all the acts of Congress. So having established this occupation and cultivation, and this is a key phrase, this gave the pioneer settler a possessory or preference right to acquire the actual legal title. In other words, the very moment you settled on a piece of land, marked out your corners, and started to improve it, that land was now removed from the mass of the public lands. It was now occupied, unpatented land. It was no longer public land. There is a legal definition for every term, word, and phrase used in the law in the United States. Okay, and the term public land has a very specific meaning. If it didn't, you could not have any criminal statutes related to public land because it would be void for vagueness, is how the courts define that. Okay, if there's a law that says you cannot pick mushrooms on Tuesday, okay, there has to be a definition. Well, what's a mushroom? Okay, in order for you to be convicted for picking mushrooms on Tuesday, there has to be some definition of what exactly is a mushroom. Okay, it's maybe that's not a good analogy, but the point is that if a word is not well defined, I'll give you a real example. In 1976, the Antiquities Act was held by the Ninth Circuit to be unconstitutional for vagueness, because there was no definition of the word antiquity. A guy went to court, he was convicted for violating the Antiquities Act because he took some mass out of a cave in Arizona in the Tano National Forest. Okay, and it's right next to the Apache Indian Reservation. These caves were used by Indians for their ceremonies and everything. Well, it turns out these masks were made in the 1950s, and so what constituted an antiquity? And so the judge said, well, there's no definition of what constitutes an antiquity. There's no way of determining whether or not he even violated the law. So the Ninth Circuit declared the Antiquities Act void for vagueness. Okay, and that is a principle in all criminal statutes. If the word is not well defined, how can you convict somebody for something that, the court can't even decide if this really is a violation of the law? Okay, so the term public land itself has a well-defined meaning in the law. In the early days of the United States, there were vast amounts of land west of the Appalachian Mountains, claimed by some of the states, the original 13 states, as their own territory. The smaller states refused to sign Articles of Confederation until the others gave up their claimed western territories for the mutual benefit of them all, and this resulted in Article 4, Section 3, Clause 2 of the Constitution, and this is what it says. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. Okay, and that territory refers to, what that term territory refers to is the public lands. And this is found in the U.S. Supreme Court decision, United States versus Grayshot, 1840. You can look it up, all these statutes. If you want to check me out, make a notation. You can go to a website called Justia, Justia. Look it up, type in the name of the case, it'll pull it up, you can read it for yourself. But this is where the term public lands, originally in the original statutes of the United States, first referred to it as lands of the United States, then they shortened that to public lands of the United States, and then they just simply started calling it public lands. But the Supreme Court said that term, public lands, has its origin in this particular section of the Constitution. Congress enacted statutes for disposing of public lands to the states, railroads, Indian tribes under a classification system that recognized rights of occupancy. And here's a quote from Barden versus Northern Pacific Railroad Company, 1892. By public land, this is the Supreme Court, not my opinion, by public land, as it has been long settled, is meant such land as is open to sale and other disposition under general land laws. All land to which any claims or rights of others have attached does not fall within the designation public land. So a piece of land that a homesteader has occupied, cultivated, settled on is not public land. And there's at least there's over a dozen Supreme Court decisions, this Barden versus Northern Pacific Railroad Company. You go look up that case and it'll give you half a dozen references to previous decisions of the Supreme Court where this is set in stone. This definition of the term public land is set in stone. If there's a right attached to it, someone has a claim, it is not public land. Why? Because you can't settle on land someone else already has a claim on. So if some other settler had settled there first, and they're perfecting their title, and they have not yet spent their 5 years in order to qualify for a patent, it's still not public land. You can't kick them off and then claim it for yourself. Okay, those people are called claim jumpers. All right? So the policy of Congress under this classification system, okay, I don't know if this pointer's working or not. I can't see it. But this term classification is very important. All land was classified as either agricultural, mineral, and then there were several other categories, those were the two main categories, but lesser categories were like swamp and overflowed land, was one other category. Later, after 1877, Congress invented a new classification called desert lands. Those are lands that could only be farmed by irrigation. Okay, so keep this classification system in mind. So Congress adopted this policy, and it was to grant agricultural homesteads that were limited to 160 or 320 acres. So if it was agricultural land, it could be claimed under the preemption acts or the homestead laws. Mineral lands were not available for homesteading or for claiming under the preemption laws. This is very important to remember. And you'll see as we get into this, the difference. When people say, what's the difference? Why is there all this government land in the West, okay? But in the East, there's very little. Okay, we'll see as we go through there, under this land settlement system that they had very early established, you'll see why. Because basically the West is mineral land, and it's arid mineral land. In the East, they got 30 inches or more of rain a year, and almost everything in the East can produce some kind of crop. So there's very little, when you look at a map of the United States, you see there's very little of this so-called federal land. Okay, I'll explain it as we go through. And in the East, there's very little. In the West, there's a lot. Okay? And it's because of this system, this classification system. Almost everything in the West was classified as mineral land. And so it was only available for settlement under the mineral land laws. And one of these key laws was this Act 1853. And under the Act 1853, Congress granted a right, and this is the language out of the Act, a right of occupation and cultivation on or to settlers on or nearby mineral lands. Okay? This is what the Supreme Court said as recently as 1987. This is the U.S. Supreme Court. Most enduringly, public lands have been defined as those lands subject to sale and other disposal under the general land laws. So if it's not subject to sale or disposal, it's not public land. Okay? It is not public land. Can you homestead? You lost. How much time do I have, Trent?
7 minutes.
Okay, well, there's way too much stuff here. So I'm going to, okay, here we're going to talk about, this. Now here's the consequences. If you own your allotment, which is a split estate right, don't get me wrong, what the Supreme Court said in Watt versus Western Nuclear, that surface right is for agricultural and ranching purposes only. Okay? So that's why you can, when they sell these ranches, that's what you're selling. You're selling your improvements, your water rights, and the right to use that ranch for agricultural and ranching purposes. The government still has this retained right to go in and cut timber or sell it commercially or allow people to take up mining claims or oil or gas leases as long as they pay for any damage to your forage or your improvements. That land is still open for disposal by the federal government under these other laws. But the fact that it is private land, now when the government comes in and says, oh, by the way, we're taking this pasture because we think it might be good habitat for some endangered species. Now that's what's called a taking. Now I'd like to be able to tell you that the government just can't take your property, but the truth is they can. It's called eminent domain. They can take your property, condemn it, and use it for whatever government purpose they want. The problem is they cannot take it without due process and just compensation. Okay, so until they pay you for your forage, like in Atherton versus Fowler, okay, until they pay you for your water rights, such as in Hage v. U.S., until they pay you for your improvements, then it's still your property. Okay, government can't just take your property. And see, that's the bureaucrats' problem. They like to take things without having to pay for it. And when you don't know what your rights are, and that's what Tim wanted me to talk about, how do you negotiate? You have to first know what your rights are. So if you're John Griffith, you can stand up to him because you already know what your rights are. And they can't just come in there and BS you because, you know, I'm going to try to jump ahead. I wanted to talk about the Endangered Species Act. It was actually first passed in 1915. Did you know that? 1913, excuse me. And in 1915, it was held to be unconstitutional because the federal government there's no power in the Constitution over wildlife. So they had to pass it again in 1918, and they made it specific to a treaty the United States had with Great Britain for migratory birds, because they said these birds were involved in international commerce, interstate and international commerce, under the Commerce Clause, the Constitution. So, but I'll just say, I'll mention 1923, this act Congress passed. It was an act for the relief of stock raisers. It said that everybody within a national forest, your title is perfected. And everybody that's outside the national forest that has a claim to land under those stock raising laws, your right's perfected. So by the time they passed the Taylor Grazing Act, guess what? They'd already had grazing districts. A lot of people think grazing districts came from the Taylor Grazing Act. It didn't. Am I almost done? 3 minutes? Okay. The main point I wanted to make, this Wildlife and Fish Conservation Act of 1934 was simply an amendment to the original Endangered Species Act. So when they talk about the Endangered Species Act of 1966 or 56 or 46 or 34, guess what? It's all one law. It's what's called paramateria. If Congress passes a law, and then later they pass another law that includes by reference the previous law, those all have to be read as one law. And when you read all of these acts that together make up the Endangered Species Act, again, it says it cannot interfere. Every one of these statutes says the government can't interfere with the rights of the state, and they cannot take private property without due process and just compensation. But you see these environmental groups get together with these federal agencies, and they have these sweetheart lawsuits where an environmental group sues a federal agency, and all they talk about is a small, maybe even just one clause, not even a whole sentence that's in the act, and they say, oh, this is a violation. Well, wait a minute. You have to read the whole act together as one law. And if ranchers own their allotments, that's private property, entitled to the same protections as any other property. So, okay, Trent's coming for me. I got to hurry. Okay, here's something all of you are going to be interested in. Okay, this is the law. This is the actual law. It says, in any criminal prosecution or civil action by the United States for trespass on such public timberlands or to recover timber or lumber cut thereon. This was if you cut trees on the mineral lands of the United States, it's a defense. If the defendant shall show the said timber was so cut or removed from the timberlands for use in such state or territory by a resident thereof for agricultural, mining, manufacturing, or domestic purposes, and has not been transported out of the same. Why? Because in 1878, Congress actually granted an individual right for you to cut timber on the mineral lands of the United States. So there's a couple of these other laws. Okay, here's one that could have freed the Hammonds. They would not be in prison today if their lawyer had known this is what the law says. And it says it's illegal to set a fire on basically Indian reservation, national park, anything, except it says unless an allotee sets or causes to be set any fire in the reasonable exercise of his proprietary rights in the allotment. They are excluded. Are they excluded from public land? They're excluded from their allotment. But if you're ignorant and you don't know the law, and they charge you with burning timber on public land, and your lawyer doesn't know the difference between public land and a hole in the ground, then you end up getting convicted. Two more things and I'm done. But guess what? Here's that Title VII of the Federal Land Policy Management. All actions by the Secretary concerned under this Act shall be subject to valid existing rights. You can read this whole thing. The whole thing is nothing but nothing that's actually be construed as limiting or respecting the rights or repeal any existing law or implication construed as terminating any valid lease, permit, patent, right-of-way, or other land use right in authorization or existing on the date of that act, so on and so forth. This is the last sentence down here. All actions by the all, not some, all actions. And here's again in the National Forest Management Act. Any revision in present or future permits, contracts, and other instruments made pursuant to this section shall be subject to valid existing rights. They have no choice. They must, but if you don't know what your rights are, and that's what this talk is all about, standing up for your rights. You cannot negotiate away your rights. There's no negotiation. If you have rights, you need to stand up for them, or you don't have any rights. You talk about mineral lands, the United States, where are they? Well, by golly. When they say, why is the West so different than the East? Because the West is different than the East. The West was settled under the mineral land laws, not the East. Those are mountains there. Okay, now there are, some national parks and stuff like that, but not like anything like you have out west. This isn't my map. BLM, right here, Bureau of Land Management. This is their map. And what does it say? Federal public land, surface and subsurface. And why is it called public land? Because you can make a mining claim or oil or gas lease. That part is, quote, public. The allotment is not. The allotment is private property. It's a split estate. Remember the Federal Power Act of 1920? The exact same language is in the Federal Land Policy Management Act. Look up the definition of public land under FLPMA. Well,
Article 6, Section 22. Trent has the right. Angus.
And I am done. I am done. And right there is a quote from our most recent Supreme Court Justice. You can read that as I descend from the stage.
No, don't leave. I'm going to give Reed Smith a chance to ask you a question.
Oh, okay.
Angus, thank you very much. I have a copy of a land grant signed by President Lincoln. Can the California Water Resources, and the land grant states that I can use the land for agriculture and other good purposes, surface, and the water underneath. Can the Water Resources Control Board of California come in and do an overlay that prohibits any of those activities?
First off, I'll say if, depending on the patent, what statute it was issued under, you got to remember that even though you could not enter land under the homestead or the preemption laws if it was mineral land, yet if there was 160 acres that was determined to be agricultural land, you could get a title. And that was the reason why it was limited to 160 and 320 acres, is because Congress did not want to give huge blocks of land that had possible minerals in it, like gold or silver. They didn't want to give that to individuals. But if you have a 160-acre homestead, you probably own the minerals under that. Now, can that stop the state from taking your land? The 14th Amendment says if the state takes your land, they have to pay you for it. Same as the 5th Amendment. You do have property protection. I'd like to be able to tell you, no, government can't take your property. But the truth is, government can take your property. But they have to give you due process and just compensation. Thank you.